Tell you, electoral bonds, these are some of those things which are conceived in sin, executed by stealth, implemented by malafides. The buck starts and the buck stops at number one. In fact, at the highest, you can assume that the original design will be known even at the most number two. That's it. That there was a fortress of a statute created by this government, especially through the 2015, 16, 18, and 19 amendments to the PMLA Act. Those introduced several draconian features of an extreme kind. So, in design, this is the government which the act came much earlier, but many of the draconian features have come now. My real point is that today that fortress has become a hut. The walls are broken, the ramparts are broken, the moat has been breached, and the time is not far when that hut will lose its remaining walls and roof also. The constitution is here, upar hai. The statute is here, 45, that is PMLA. Sarvopari kya hai? Constitution. The constitutional mandate of Article 20, 21 and 22 says that trials can't be interminable.
Should the PMLA Act be repealed?
I will be very thankful if this government does not bring amendments to make it. People have come out of jail in 2 minutes after joining. People have got tickets to fight for the BJP. So when you have this paradigm, why the hell are you mad that you'll repeal it? The Honorable Prime Minister has the same rhetoric, the same idiom, the same challenges, the same subsbag, and there is too much of rhetoric there and jumlabazi.
Hello and a warm welcome to HW News, your one-stop show, truth be told, for some engaging and provoking conversations. Now, the 8,000 crore electoral bond case has suddenly become alive again, thanks to the Metropolitan Court in Bangalore, which ordered registering an FIR against Finance Minister Nirmala Sitaraman. Though the next day there was a quashing petition, and now the case has been posted further. But the thing is that will we ever come to know the reality of electoral bond case? Because the day the FIR was registered against Finance Minister, Congress held a press conference. Eminent Congress leader Abhishek Manu Singhvi and Jairam Ramesh held a press conference that day saying that this whole electoral bond case has unmasked the true nature of the ruling party. Dr. Abhishek Manu Singhvi had said. But apart from the electoral bond issue, we also need to talk about the manner in which the PMLA cases have been handled by the ruling government, by the enforcement agencies. And at the center of all this is Dr. Abhishek Manu Singhvi, who is an jurist, a veteran Congress leader, and Rajya Sabha MP. And he joins us this evening. Thank you so much, Dr. Abhishek Manu Singhvi, for joining on the news. It was wonderful to have you on the program. And I'd like you to take you back to the press conference which you held that day. You said that this electoral case, this FIR actually has unmasked the true nature of the ruling party. Now, do you think, will we ever come to know what happened really in the electoral bond case? And will there be a stringent action against the finance minister? Where does the buck stop here? Does it not stop at the top, which is the prime minister's table?
Since the matter is sub judice, let me just give you the context and the facts. I don't want to opine on the merits or the outcome. The first point to remember is that this is by a complainant or an applicant who has nothing to do with the Congress party. Admittedly, he is unconnected, admittedly, with the Congress party. Number two, it is not just a walk-in complaint by someone and registers a complaint at the police station. The court applied its mind and said, look, please register an FIR, give a direction to register an FIR, and that is how it was registered. Number three, the electoral bonds issue on the merits is very simple. There are cases, and they've come in the public domain. We know the names, they've been published by our newspapers, of 2 or 3 simple models. Model number one, You buy electoral bonds of gigantic amounts in value, and within a few days, few weeks, few months, you get gigantic government contracts. So the quid pro quo is established clear. Chanda do, contract lo. This is another form of the most crudest form of bribery, except that it is intended to be opaque through the purchase of an electoral bond. The second model, or the second kind of category is everything is hunky-dory. You are doing your own work, no interference. The ED knocks at your door. Let me for a minute assume that the ED knocks at your door unconnected in the normal course. You are harassed, you are scared, you are called. In some cases, you are arrested. Every time you seek bail on legitimate legal grounds, you don't get it. Well, suddenly your son and your wife have a bright idea. Let's go and buy electoral bonds. You go and buy again a gigantic amount of electoral bonds, and you see the difference in the order sheets. Bail is not opposed, less opposed. You are granted bail. You are released. You are allowed to be, not called. Ultimately, the case goes into what is called Thanda Basta. Third category could be that you are actively associated with funding the BJP party through electoral bonds, but through dubious means. You as Neelu Vyas has a paid-up capital or as a kitty of 100 rupees, but you are giving electoral bond donations to Abhishek Singhvi of 1,000 rupees, 10,000 rupees. This great love for Abhishek Singhvi when your total net worth is 100 rupees. Will you ever pay 10,000 rupees? So there are all these kind of models which are there, and they've come in the public domain. Now, the persons who filed the complaint have, of course, made a specific allegation that this is harassment, this is blackmail, this is extortion, this is intimidation, this is extraction, and that is why it's a criminal offense. It is not voluntary. It is not out of great love and affection. It is all by pressure tactics, intimidation, and harassment. And that's the heart of the charge. Now, at the moment, there is an interim stay. There is no final order by anybody. It was the start and the commencement of the whole issue. And as and when it goes forward, assuming there is no stay by the High Court, the matter is allowed to go on. Then the next normal steps will be summons. I call you. You have to come. Interrogation, questioning, paper record. And ultimately, if the police finds that there is complicity, there can be arrest. There is no problem. There is nothing above the law. But before that arises a situation, before that, which is nothing to do with arrest and summons and interrogation and law. We are talking here of Naitik Zimmevari. On moral responsibility, in case the investigation, the summons proceeds, there would be clearly a call, a situation for two things. One, a resignation. After all these agencies in various ways are controlled by the finance minister and the finance ministry. Secondly, for ultimately some kind of independent overall supervision by a Supreme Court monitored body. Thirdly, politically, and I don't put much store, but that's only a political answer. I'm not saying we want it now at all, because sometimes it makes it diffused, a JPC. I'm not asking for it now, and we did not ask for it in the press. So I'm just telling you the options. And also to be remembered is that these are not decisions that we take, which they are well above the pay grade of the finance minister. These are decisions taken by one and two. They are decisions taken at a different level, and therefore we are now talking really of somebody being a puppet or just an implementer. The real people we all know who they are.
Dr. Singhvi, I really want to understand from you that this particular order by the Metropolitan Court has it opened a Pandora's box as far as the investigation into the electoral bond case is concerned? Because last August, Supreme Court had dismissed any sort of inquiry into the case, and after which now the Metropolitan Court has ordered an inquiry. Of course, now the case is long. We do not know how long it will be. Has it opened a Pandora's box, and this investigation could really unearth those features which really have not come out.
Now, the Supreme Court has never quashed, stopped, or prohibited the individual or a individuated criminal investigation. The
Okay.
Supreme Court said that on a general basis, we are not taking any action. They already quashed. They quashed the scheme of the electoral bonds anyway.
Yes.
This is a specific criminal complaint. This is nothing to do with the Supreme Court prohibition. Now, this criminal complaint can go forward. It can lead to all the steps I've told you, 4 steps, or it can be quashed by the High Court. That's a matter to be seen. But there's no question of this filing of this complaint being prohibited by the Supreme Court.
Does it give you more, does it make you hopeful that there will something happen as far as the investigation into the
Let
electoral
me
bonds
tell
is concerned?
let me tell you, electoral bonds, you have to step back a little bit and see the thing in the larger perspective. These are some of those things which are conceived in sin, executed by stealth, implemented by malafides. The very concept, the very design of this concept is opacity. The very object is one-sidedness. I am in government. Somebody buys the electoral bond. The ruling party is the natural beneficiary because people are not foolish to waste their money on non-ruling parties easily. And nobody can find out. It's not good enough to say that, look, Neelu Vyas can apply to SBI and they will have all the published things. We never had it. All these years, simple answer is, you got it only when the Supreme Court. And remember, don't forget one thing. Supreme Court, and I blamed at that time and I blame again, in the initial years, unnecessarily delayed adjudication of this issue. And I would squarely blame the delay. It should not have been allowed to happen. And it is, I think, a credit and a kudos to the current dispensation of the Supreme Court that took up the matter. And after they took up the matter and they passed an order clearly saying whatever I've said. What did the SBI do, Neelu? Do you remember that? After the judgment, the SBI comes and says, we want a few days to revert.
Yes.
After a few days, they come and say, sir, I'm very sorry, we need 6 months. I'm the SBI of the country. I need 6 months to start collating. The Supreme Court said, rubbish. You're not extending the timeline, do it tomorrow. And they ultimately came out with the information. So what is this happening? This is an attempt to block, to conceal, to obfuscate, to digress, to divert. And it was only when they were forced to the wall that you got this thing. And this thing came out, therefore, because it was designed for opacity and for obscurity.
You've explained it very well, that what the scheme looks like and how has it been designed. The intentions also look very, very obvious. But where do you think does the buck stop in this case? Would it be just enough by saying that, Nirmala Sitharaman should resign, the finance minister? Or
Obviously not. You know very well. I know very well. The Janta knows very well. The country knows very well. I just said this is well above her pay grade. She cannot decide to design and implement this. This is like demonetization. Could you do it? Could the top minister in the country do it? You cannot. It's obvious. So we all know the buck starts and the buck stops at number 1. In fact, at the highest, you can assume that the original design will be known even at the most number 2. That's it. There is no number 3 involved. There is no number 4, 5, 6.
But how hopeful are you now as far as I don't know what's going to happen now in this Karnataka High Court case, because the other day when Adarsh Iyer, the main complainant, went, so they said that you are not directly the aggrieved. This is what Karnataka High Court had to say. And now, of course, they have to give an explanation. And I think on 22nd of October, the next hearing is posted for. But do you think that can we expect something earth-shattering at the Karnataka High Court?
Legal adjudication is not and should not be, in this sensationalism or scattering as you put it. There's a process. I cannot second guess, nor am I here to discuss sub judice the outcome issue basis or the merits basis. It is entirely possible that the challenger before the single judge is dismissed. In other words, the complainant wins. It's equally possible that the complaint is quashed. That I cannot say, but I can certainly say that assuming that the complaint is quashed, the complainant has a further right to appeal. It's not going to end here. Secondly, it is not a question of you being personally aggrieved. There are certain matters where if FIR raising in rem can be raised. And this is a larger issue where the investigation only started. And if there is harassment, even of relatives, even of close persons, this can be sustained, but that will be decided ultimately by the court.
Right. I also want to talk to you, Dr. Singhvi, about the PMLA cases because you yourself have been fighting for these cases and you fought them well. Look at what happened to Kejriwal and several other cases which you've handled. And now we see a pattern where court has started making some very strong commentary on the ED officers, the way they PMLA cases. What Supreme Court said in Senthil Balaji's case. Then also previously, then we had a and Haryana High Court judge making a very strong commentary, Justice Sindhu, was saying, you need to follow certain UNO guidelines as far as interrogation process is concerned. And this was in context with Surinder Pawar's interrogation, went on for 14 hours and 40 minutes. Now, is this a late awakening by the court? This was something which the court was observing right from day one. I mean, I'm just curious to ask you this question. Is it a late awakening of the court?
Well, I hate to admit it, but I think you're broadly right to the extent you use the phrase late awakening. I have in fact spoken in the recent past saying that there was a fortress of a statute created by this government, especially through the 2015, 16, 18 and 19 amendments to PMLA Act. Those introduced several draconian features, several features of an extreme kind. So in design, this is the government which the act came much earlier, but many of the draconian features have come now. Second, having designed that, they created this fortress of fear, of foreboding, of intimidation, which seemed very unassailable, impregnable fortress. And unfortunately, courts across the country, and especially the trial for the matter started, fell into that trap of looking at it as an impregnable fortress. And then along came Vijay Madanlal Chaudhary, which is the basis of making it that impregnable fortress. It was actually a draconian, it was actually a retrogressive, and it was used even much more retrogressively to create a hawa about it, to create a foreboding and a forbidding air about it. My real point is that today that fortress has become a hut. The walls are broken, the ramparts are broken, the moat has been breached, and the time is not far when that hut will lose its remaining walls and roof also. Because Vijay Madanlal Chaudhary is coming up for reconsideration starting 16th October. But what has happened in between? All the cases you are mentioning, that this two judgments, and I had the privilege of succeeding in two. All the others are only following them. One is Manish Sisodia, one is Arvind Kejriwal. All the judgments cite those same. How they fell down? The original falling down started with Pankaj Bansal, who had the privilege of arguing, where they said that grounds of arrest, Neelu Vyas is told when getting in the car, your grounds are 1, 2, 3. Neelu Vyas's brother is told when getting off the car that the grounds are ABC. Neelu Vyas is shown the paper, here are the grounds. But Neelu Vyas is never furnished in writing the grounds of arrest. So Pankaj Bansal decided that don't give those to Neelu Vyas, the entire arrest is illegal. That's the first wall or the rampart which fell down. Second, in Kejriwal and Sisodia, they said that, look, forget the grounds of arrest. The necessity to arrest has to be justified by you. The case starts 2 years ago, Neelu Vyas is never called. For 2 years. Suddenly she is called after 1.5 or 1 year, 9 months. And in the next calling, she is arrested. तो अरे भाई 2 साल से आवश्यकता नहीं थी, जरूरत नहीं थी, तो आप डेमोन्स्ट्रेट करिए कि नेसेसिटी ऑफ अरेस्ट क्या है. अरेस्ट का पावर इज नॉट इक्वल टू exercise of the power, because you have the power to arrest. That's the second part of the wall which fell. The third is the reason to believe, which you as the police officer has to record on the file, must show sufficiently that your reason to believe is informed by material. I can't say on the file, Neelu Vyas is black hair, I don't like black hair, I want to arrest her. That is of course an example, but let me say Neelu Vyas did not come once because I called her. Twice she was traveling abroad. I believe she should be arrested.
Hmm.
The reason to believe on the file must disclose credible reasons. They're all linked. Then, fourth and most important, they created a hawa about section 45. अरे भाई इसमें तो bail ही नहीं मिल सकती. This is a bar to a bail, a prohibition to a bail. You can't get bail. Because the word used in that section absurdly in the design created by the BJP government is not guilty. Now, I can't prove that you're not guilty at that stage because the trial has not started. So now courts after courts started holding that not guilty doesn't mean that bail nahi mil sakti aapko. It only means that the threshold is higher. So that's the fourth strong one. The fifth and the strongest wall which fell. This is the biggest wall which fell. That is directly in Manish Sisodia and Arvind Kejriwal. And all the other judgments are following them now. And that said, look, the constitution is here. Upar hai. The statute is here. 45. That is PMLA. Sarvopari kya hai? Constitution. The constitutional mandate of Article 20, 21 and 22 says that trials can't be interminable. Delay activates Neelu Vyas' fundamental right to get out of jail because she's not supposed to wait in jail while the trial is going on with how much? 2 lakh documents, 400 witnesses, etc., etc. So they say for this matter, assuming that 45 bars your bail, even then the constitutional mandate of delayed trial or anti-delayed trial is higher, and that will trump. That will trump 45.
Dr. Singhvi,
following this, the high courts and the trial courts have become emboldened now. I find the same learned judges very amusing and very satisfying, very good to see. Now saying, no, out you go, try never go well. I agree with you, the late awakening is correct. There was no reason why you could, there's the same law. The law has not changed. You have the boldness not to articulate it.
Right, but you explained this.
Vijay Vadalal Chaudhary will go shortly. I'm confident, hopefully, that the judges will review it. Of course, that's a matter coming up on 16th of October. Then you will have from a fortress to a hut, and from a hut to a ruin, a derelict ruin.
I was actually just coming to that bit because you beautifully explained how this entire fortress has been reduced to a hut, and you already explained how all the walls have already tumbled down. But the point is that has this not completely defanged, if I may use that word, has it not defanged the PMLA Act? The intention with which the enforcement agencies were arresting, detaining people, going after, chasing, all those, I mean, those were kind of weapons, which were developed. Has it defanged?
You see, at one level you are right, at one level you are wrong. What I've said about fortress, hut, and ruin is of course defanged, obviously. So it is defanged. It is reduced the weaponization. Number two, there is still a lot of weaponry which needs to be defanged. Take, for example, a simple thing. Have you ever heard of such a big crime, 7 years in jail, difficult bail, and you're not given a copy of the ECR?
Yes.
If you want PMLA, PMLA is a consequential offense. I murder you is a CBI offense, IPC offense. When I get money out of murdering you, then I take the money, then I convert it, project it, transform it. That becomes PMLA. Now, in the main murder offense, I get the FIR. But for the money laundering allegedly, which is conversion, I don't get any FIR. They call it DCR, nothing. So ये तो सीधा एक अजीबोगरीब बात है. One of the issues pending in Vijay Madalal is why do you do it? Then other issues are, suppose I take money from you. So I have committed the crime, I have murdered you. But the money I have taken from you, I have put under my bed. And I have not done anything with it. That is cash money, you can have an income tax thing. But I have not, the words in the statute are used, projected, converted, or laundered. Laundering of money is the conversion of money by manifesting itself in a new property, in a new activity.
Right.
That has been forgotten. That again is up for consideration. So this is the answer number two. The remaining parts of the defanging remain. And third and most important, even if all this is done, defanging is not an easy way in the common law system which we follow. Common law system means it's case by case. So today we know that grounds of arrest must be given to Neelu Vyas. Nothing prevents me from making your illegal arrest tomorrow also and not giving you grounds of arrest. मैं नहीं देता आपको. एक बार तो अरेस्ट हो गई आप, एक बार तो गिरफ्तार हो गई, जेल चली गई. अब आप जेल में सड़िए, फिर आपके वकील एक एप्लीकेशन डालेंगे, वो आएगी, उसमें जवाब का नोटिस होगा, अंततो गत्वा कोर्ट आपको रिहा कर देगी। उस प्रोसेस में 1, 2, 3 महीने लग जाएंगे। इसलिए तीसरा पॉइंट है, द प्रोसेस इज द पनिशमेंट। In our system, it's an individual case-by-case approach. The fact that in Pankaj Bansal it was held that you have to give the ground doesn't mean that Neelu Vyas can't be arrested without the ground. Neelu Vyas will win the case. But by the time she wins it, she will suffer. My intention is to make you suffer. I can make you suffer for 2 months.
But Dr. Singhvi, if a court rightly has started defanging this law, has started bringing down the walls of this fortress, what I don't understand is that, the period which is lost as far as the victims are concerned, why can't the court get into some kind of punitive measure against these ED officers, against these enforcement agencies? Look at Arvind Kejriwal. Look at Manish Sisodia's case was horrible. Almost more than a year he was in jail. And how would the enforcement agencies compensate for that time for his family and everything?
You are making a very good point, but unfortunately, the sad truth is nothing has happened on that front. And I don't think, frankly, nothing can happen on that front. That's the sad part. You see, our system has certain principles which were designed for safeguarding, but they have become abusive. One of the principles is that ultimately a decision is wrong. What holds it to be wrong? And from that day, the release follows. You are released or you are let off. But equally, the principle is that we are not supposed to hold individuals guilty of deliberate wrongdoing unless you prove malafidis. Now, it is impossible to prove. It is actually impossible to prove that Abhishek Singhvi has personal malafidis against Neelu Vyas because he knew her for a long time ago and he hated her and he said, look, I'll fix her. Unless you prove that, which you cannot prove against any ED officer, you cannot get punitive measures. That's the problem. And that part of our law is underdeveloped. It is known as a constitutional tort. In other countries, A, the police system is more responsible, and B, the punitive measures are worse. But I think that will take a long, long time. The inherent delays of the system, the lack of the almost impossibility of proving any malafidis mean that is going to be, but that certainly is the correct deterrent if it happens, when it happens.
So my my last 2-3 questions, a few questions I've left, for the politics as well. But a question related to the PMLA Act. Now, since it has become such a draconian law, and like many other draconian laws, which have been withdrawn, which have been repealed, do you think that now the time is ripe? And I don't know whether this government would do it or not. But should the PMLA Act be repealed?
Well, that's
or one wouldn't go to that extent.
See, first of all, that's an idle question. I will be very thankful if this government does not bring amendments to make it more draconian. What are you talking about? You are assuming a certain amount of compassion, benevolence, a good governance approach. I'm sorry, I don't give any credit to the government for that. They know that they have weaponized it. They know they've used it as a tool. You must know the conviction rate in PMLA is about, I forget the figure, 0.75 or under that in political cases. Now, what they tell you is that we have hundreds and thousands of cases and we have very few political cases. They're right. But that's a misleading statement to make. Ask them that what are the total number of political cases they have. Let us assume there are 100. Then ask a second question. Out of those 700 political cases, how much are against oppositions? 95%. That's the correct statistic. So if you have that statistic, see, a large number of corporate matters, you're a CMD, you're a fraud, you are some kind of a trickster. We are not concerned with those. We are talking about political cases now. Out of 195% are against only one class. The other class has a laundry factory. In the press conference yesterday, I gave 10 names. I have no hesitation in giving. That 10 names were active cases at an advanced stage, closure report. Maharashtra ke varisht neta ke baad closure report. People have come out of jail in 2 minutes after joining. People have got tickets to fight for the BJP. So when you have this paradigm, why the hell are you mad that you'll repeal it?
Absolutely.
Therefore, this is a very benevolent kind of question which is unreal. And secondly, I don't think as and when the time comes, let's say after 20 years when we've forgotten this bad era of PMLA misgovernance, even then there is a place for PMLA. There is, you see, PMLA was designed as India's obligations to international treaties.
Yes.
It must remain. The idea was narco-terrorism. The idea was global narco-terrorism or gangs, organized crime at the international level, what we call Makoka in India, that kind of organized crime abroad, across borders. Of course we need it. We can't be a tax haven for people doing narco-terrorism. But tell me, how are you using it? Was it ever intended to use it for a political class like this? अभी सिद्धरामैया का मामला 1 हफ्ते पहले सैंक्शन अपहोल्ड हुआ है। 1 हफ्ते पहले लोकायुक्त पुलिस को इन्वेस्टिगेशन शुरू किए हुए 3 दिन हुए। ये बताइए कि 3 दिन में how does the PMLA ED make up its mind on a prima facie basis to register an FIR? In 3 days, how have they found evidence of money laundering for a 1992 acquisition of land, a 2010 gift, a 2020 exchange? How? So this was PMLA was not intended for what you call that FATFA and all that foreign financial applications. That must remain. You should not throw the baby out with the bathwater.
Right. Now, my last two questions related to the evolution of Rahul Gandhi. And one cannot help but talk about this since elections time, and Rahul Gandhi is speaking continuously in his rallies, and so is Prime Minister Narendra Modi. And a continuous comparison is being made between Rahul Gandhi and Prime Minister Modi. What would you really say to the manner in which Rahul Gandhi was projected in yesteryears and now how he has evolved? So, where do you really see the Prime Minister's image? People have started saying that 56 inches has shrunk. There are all sorts of imageries, the way people describe. But how would you really see the comparison between the two?
Neelu, these are holistic perspectives. These are, everybody evolves. I mean, you evolve, I evolve, time passes. There's no question of everybody, and there's no doubt that things change. The biggest static thing is change. Therefore, there is no doubt about it. What has really happened? I don't think Rahul Gandhi has changed that drastically at all. One, he has always been fearless to a fault. Two, he has always called a spade a spade. Tell me which of these characteristics have changed drastically. They may be changed in degree. Three, he has stuck to his guns. Four, yes, he has embarked on something new, yatras, which are physically excruciating and emotionally very binding. That is something new. Five, the law of diminishing returns has set in quite a while ago for the Prime Minister. What you had thought once time to be a fantastic jumla, a great oratory and rhetoric, you slowly start thinking that there is sincere. You heard of IQ, EQ, I have a SQ, sincerity quotient. That is the sixth thing which about Rahul Gandhi and the Prime Minister stands in stark contrast. The SQ in one and the SQ in the other is Zameen Asman ka farak. Number 7, there is then also a feeling that the Honorable Prime Minister has the same rhetoric, the same idiom, the same challenges, the same sabzbag, and there is too much of rhetoric there and jumlabazi there. Now, these are things which evolve, no doubt. But ultimately, it is you who have evolved much more than Rahul Gandhi has evolved. Because you have realized, just by calling you names every time and trying to belittle you, why should you get taken in? But we have not taken in. Now they realize that the SQ being different, we should not have been taken in. So you start saying that he is still speaking the truth. But your perception of him has changed much more.
But after the election results, and on 8th, we will have the election results before us for Haryana and Jammu Kashmir. Maharashtra also doesn't look like a very good picture for BJP. So at the end of Maharashtra, Haryana, Jammu Kashmir and Jharkhand elections, where do you really see Prime Minister Modi? I mean, many political analysts say that he would also become like an illegitimate prime minister. Would it be right to say that then?
I don't think that's fair. To be fair, there's no question of illegitimate prime minister. And I would not agree with that. And I understand the way of putting it. I understand the spirit behind putting it, but I would not agree with it. To your list, you must start by saying, you said, where would it be? Where would it lead? The answer is downhill. It's only downhill in at least the context you have given. The top hill was one day before the results in June 2024. From the June election date result, at the end of the day, you have lost between 70 to 80 seats. 70 to 80 is not a small number. So thereafter, it is downhill only. That 70 to 80 is a steep decline. Look at the names of the 4 states you took. Maharashtra is not a mere state. It is, I would say, 2 to 3 states in one in terms of the economic powerhouse, the sheer size, the importance. The BJP is extremely worried, otherwise they would not have delinked Haryana and Maharashtra for the first time in decades. Never before. Because they want to misuse the government and hold out lollipops. But imagine the kind of spirit of change which will flow across the country if you add up the synergy of a Haryana where people, even their best friends, don't give them a chance. Of Maharashtra, where they are a very difficult terrain, but the campaign is yet to start. On Jharkhand, with the kind of shenanigans they have paid, including trying to win over the person who was temporarily the CM, I think there has been a reaction. And then Jammu and Kashmir, even their best friends believe that they are trying to have a division by setting up, the kind of bail opposition you've had to some of the names means that they're trying to set up a spoiler, so to say. The word spoiler is the most charitable word you can find. So you have here a sense of D&D, despair and gloom and dejection, if these results. But of course, the electorate is the ultimate master. Let us wait. But overall, the scene looks pretty bad for them.
Thank you so much, Dr. Singhvi. It's always wonderful to have you on the program. Thank you. Thanks.
2019, the year that changed Maharashtra politics forever.
आणि मला खरंच आज वाईट वाटतंय की चुकीच्या माणसांसोबत आपण कारण नसताना गेलो होतो.
मी देवेंद्र गंगाधरराव फडणवीस ईश्वर साक्ष शपथ घेतो की
मी अजित अनंतराव पवार गांभीर्यपूर्वक दृढकथन करतो की
मी उद्धव बाळासाहेब ठाकरे ईश्वर साक्ष शपथ घेतो की
श्री एकनाथ शिंदे साहेब यांना भारतीय जनता पार्टी समर्थन देईल आणि श्री एकनाथ शिंदे हे मुख्यमंत्री होतील.
मी एकनाथ संभाजी शिंदे ईश्वर साक्ष शपथ घेतो की
मी अजित अनंतराव पवार गांभीर्यपूर्वक दृढकथन करतो की.
Now, as Maharashtra gets set for the 2024 assembly elections,
we believe that we have the infrastructure, we have the know-how, we have the experience of covering Maharashtra. We want to cover the Maharashtra elections. Now, for us to cover the Maharashtra elections, we need some funds, we need some money. We need around 5 to 6 lakh of rupees. I would urge you to contribute to this venture. Give us that 6 lakhs so that our journalist can go to nook and corner of Maharashtra, find out exactly what the problem of Maharashtra is.
log on to our website hwnews.in, click on the subscribe us button, select an amount you wish to contribute and support independent journalism.
Stay ahead with our cutting-edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.